All right, this is business law chapter summary number 6. The chapter starts off with tort. I didn't know what tort was. Tort is an injury to another's person or property, a civil wrong. Tort cases are commonly referred to as personal injury cases, although a tort case may involve harm or solely to property. So, I'm just gonna take it as it's just like damage to a person or property. For the most part. The primary goal of a tort law is to compensate for innocent persons who are injured or whose property is injured as a result of another's conduct. But tort law also fulfills other important social goals. Okay, that sounds like assault, which actually is mentioned in this chapter. After tort, it talks about compensatory damages, nominal damages, punitive damages, and classifications of torts. International, negligent, or strict liability, which talks about international is a civil wrong that involves taking some purposeful action that the defendant knew or should have known would harm the person, property, or economic interests of the plaintiff. Negligent, a civil wrong that involves a failure to meet the standard of care a reasonable person would meet, and because of that failure, harm to another results. Strict liability is a civil wrong that involves taking action that is so inherently dangerous under the circumstances of its performance that no amount of due care can make it safe. Then it goes into assault and battery, which is intentional placing of a person in a fear or apprehensive of an immediate offensive bodily contact. Battery is intentional, unwanted, or offensive bodily contact. I had no idea what assault and battery was. I genuinely thought it was like breaking and entering. Then it goes into defamation, libel, and slander, which is spoken defamatory statement. It talks about absolute privilege, conditional privilege, public disclosure of private facts, which is a privacy tort that consists of unwarranted disclosure of a private fact about a person. Talks about false lights, invasion of privacy, trespass of realty, which is just trespassing property, conversion, disparagement, unfair competition, misappropriation, and negligence. Goes into negligence per se, contributory negligence, and assumption of risk, which is a defense of negligence based on showing that the plaintiff voluntarily and unreasonably encountered a known risk and that the harm the plaintiff suffered was the harm that was risked. Chapter 12 goes on to start talking about common negligent actions leading to product liability cases, which is negligent failure to warn, provision of inadequate warning, negligent design, negligent manufacture, testing of or failure to test, or advertising. Statute of limitations, a statute that bars actions arising more than a specified number of years after the cause of action arises. Goes on to do the statute of repose, state-of-the-art defense, a warranty, a guarantee or binding promise that goods or products meet certain standards of performance. Express warranty, implied warranty of merchantability are all mentioned after the general over topic of warranty. Goes to talk about to meet the standard of merchantability, you must pass without objection in the trade under the contract description, must be of fair or average quality within description, must run with variations permitted by agreement of even kind, quality, and quantity within each unit and among all units involved. The rest of the chapter goes on to just talk about the courts applying the feasible alternatives test, look at the following 7 factors of usefulness and desirability of the product, its utility to the user and to the public as a whole, all those, and market share theory, malpractice suits, and Alchemir's doctrine.